Business number BLD 18-00387. I don't know what that phone in the back is, but where we left off was our appellant had just finished presenting their witnesses, and now we are going to turn it over to the city, and Mr. Haney has a few very brief opening remarks, and then you'll proceed with your witnesses. Is that accurate, Mr. Haney?
Yes.
Okay, well, thank you. Please proceed.
So by way of opening remarks, I think this case is relatively simple. We're focused on one particular provision in the code and one particular part of the building. We're focused on the exiting and specifically on the locked door between the hallway and proposed tenant space B. The code requires, and we'll provide citations, but the code provides that every space on the third floor of a building is required to have access to 2 exits. Every space. There are certain exceptions which do not apply here. They're noted in our decision that went to Mr. Moe, which is an exhibit. But the exceptions do not apply here, and the code specifically provides that there need to be 2 exits to every space, and those exits must be independent, and those exits must be accessible at all times. If in fact Mr. Reithner in 2013 approved a locking mechanism on this door, that was an error. We note that it is on one of the plans. It says on one of the plans that was presented, it says this door to be posted, note to be open during regular business hours, but that was an error if that was approved. This is not a situation that falls within the provisions on that the code allows for such signage on locking doors. You would have to apply that by analogy, but as we put out in our decision in this matter, the code does not allow that except on the main exit door. We intend to present the testimony of 2 witnesses today and possibly a third. We intend to submit the testimony of Mr. Hinton, who is the city building official, who will testify concerning his review of the code and his review of the permit involved here. We'll also present the testimony of Mark Lawrence, the assistant fire marshal who reviewed this code, and he'll explain his review of these permits as well as his review of the proposed interlocking mechanism with the fire alarm system. We believe that based upon the testimony of those witnesses and possibly Mr. Gray, who is the plans examiner on this particular matter, that we'll present a case that will allow you to concur that the building official has appropriately exercised his authority to deny the permit based on the locking door.
Okay.
That's all I have
Thank
for
you,
now.
Mr. Haney.
We'll call Harry Hinton.
Okay, thank you. Do you swear affirm to tell the truth in any testimony you give here today?
I do.
Thank you for being here, Mr. Hinton.
Mr. Hinton, would you please state your full name and give your business address?
Harry Edward Hinton, and my business address is 1775 12th Avenue Northwest, City of Issaquah. And I am the building official for the City of Issaquah.
Mr. Hinton, could you tell us what the general duties of the building official are?
The general duties of the building official are to enforce the building codes that are adopted by the jurisdiction, make sure that plan reviews are done per the adopted building codes, make sure that inspection work and the construction work is done in compliance with the building codes and with the approved set of plans, and to review when situations come up to verify whether or not they meet the intent of the code and potentially either rule one way or another.
So can you give us, Mr. Hinton, just your general background in building positions over the course of your employment history, and summarize your history related to the building code.
Starting back in 1984, and this was before I went to the dark side, went to building, I was a general contractor, and I also drew my own plans and documents which I submitted for my projects. In 1997, I was hired by the city of Stockton, and I started there as a building inspector, worked my way up to supervising building inspector, which had significant more authority. And I was told by my building official in 2000 that I was wasting my talents, and so I went out and looked, and I became a building official for the first time for the city of Patterson. I have been an acting building official since 2000, and I have worked in numerous jurisdictions, both small and large. First one was in the city of Patterson, then I was in another jurisdiction, Galt. I've worked in Lompoc, I've worked in Redwood City, I've worked in as a consultant in another number of other jurisdictions, and recently I was hired back January last year to be the building official for the city of Issaquah. I have 23 certifications through ICC, through all aspects of the building codes, building, plumbing, mechanical, electrical, accessibility, and some special provisions, special codes, structural masonry, areas like that. And so I've continued my education, continue my code training and knowledge all through these years. So that's where I am.
What specific duties do you have as a building official with respect to building permits and tenant improvements?
I oversee the issuance of building permits to try to verify and make sure that they meet building code requirements. I have staff that do the work, and I oversee their work, both in plan review and in an inspection.
And is Mr. Gray one of the people whom you oversee as a member of the staff?
Yes.
What about Mr. Lawrence? What is your relationship with the fire code and with Mr. Lawrence?
Mr. Lawrence, in my opinion, is an equal as far as what our jobs and our duties are. Our whole intent between both Mr. Lawrence and myself is to make sure that buildings are compliant and are safe. And we work very closely together. Very closely together. It's really nice. His office is right across the way, so I can throw a note over to him, whatever. But and just to kind of add a little something, a lot of what is in the fire code has also been adopted as part of the building code, especially Chapter 10 and both of them.
And is Chapter 10 the exiting requirements in the
Yes.
fire code and building code?
Yes.
And would it be fair to say that Mr. Lawrence's primary responsibilities relate to the administration and interpretation of the fire code, while yours relate primarily to the interpretation and administration of the building code and the other codes, like you mentioned the mechanical code, plumbing code, et cetera?
Yes.
Mr. Hinton, when it comes to the decision as to whether or not to issue a building permit or to deny a building permit or tenant improvement, who has the final say, yourself or Mr. Lawrence?
Myself,
So the building official makes the final determination.
yes.
Now, there's been testimony from the other witnesses for the appellant today, for Mr. Moe, about what is being proposed in this particular case. Can you tell me what the building permit or tenant improvement that you were asked to review in this case was?
That would have been the 2018 permit application, which would be the plans that we're looking are on the right, 820 or 82.0, and that design and that application.
And what did you understand the scope of work to be that you were being asked to review?
The scope of work was that they were going to be adding office space in this area in tenant B. That was my understanding as far as the application, the submittal.
So when we heard testimony earlier about partition walls, those were partitioning off offices for within that tenant space B?
Yes.
What is currently in the tenant space B?
Prior to this, from what we've seen, and I haven't gone to the site, it is open.
So there were no offices, it was
No
just
offices.
a large open space.
Right.
Were you advised on what the proposed tenant was?
My understanding, the tenant was going to be in attorney's offices.
And in the previous space, which was this large open space, what previous tenants are you aware of that were located in that space?
None.
Now, would the building official have issued a certificate of occupancy for this space if it was not built out?
I wouldn't have, no.
Is issuing a certificate of occupancy, is that something that you look at? You want to know who the tenant is and what use is being made of the space?
A certificate of occupancy is very specific, and it's very specific to all the spaces in the area, and they are listed, and it's determined and listed as far as what the spaces are, square footage of the spaces on a certificate of occupancy.
Did you, Mr. Hinton, go back and look at the city's records in order to determine what other uses were made of this tenant space B, I think is what we're calling it, over the period since the building was built up to today?
Yes, I did research and asked research to be done, and I also consulted with both the fire marshal, Mark Lawrence, who was here at the time, and also with the building inspector who did inspections for this third floor and the tenant improvements.
And did you find that there was any specific occupancy permit or any specific occupancy that was authorized for this tenant space at any time?
I haven't been able to find any information specifically for tenant B.
Did you also search the city's files in order to determine whether there were any business licenses issued?
Yes.
And did you find any business licenses issued for tenant space B?
No.
Would that be something that you would have expected to find if that space was actually occupied?
Yes.
What would you have expected to find?
I would expect it to find a business license. It would specify the type of business and the use of the space, who the tenant is.
And you were unable to find those?
I could not find it.
Now, we've been focusing on this doorway, the locked doorway, but I would like to ask you just first, before we get into that, there appear to be three separate spaces on this, in this floor plan that we're seeing. If I refer to them as tenant space A, tenant space B, and area C, will that suffice?
Mhm.
And tenant space A is the area on the, in the southern portion of the building. Tenant space B is on the east side of the building, and then space C is in the northern part of the building. Would that be accurate to refer to it that way?
Correct.
Can you tell me, Mr. Hinton, what building code was in effect in 2013 or 2012 when this building was originally approved?
In 2013, that would have been the 2012 IBC.
Okay. And what building code is in effect now as you're reviewing the 2018 TI plans?
And that's the 2015 IBC.
We've been talking about exiting requirements, Mr. Hinton, throughout these proceedings. Have the codes changed significantly between the 2011 code, under which the original plans were approved, to the 2018 code with respect to exiting?
You're talking about the building permits in 2011 and 2018.
Yeah, what I'm asking is, you've testified, I believe, that the 2011 code was what applied when the original permits, or when the permits were applied for in 2013, and the 2015 code is what applies to the 2018 permits,
Not
correct?
accurate. When the building was originally built, the building code that was in place at that time was the 2009 IBC. When the tenant improvements and that permit was submitted for 2013, that would have been the 2012 IBC. And this last submittal is under the 2015 IBC.
So there have been three separate building codes that have applied to this building, to those three separate permit years that we're talking about.
Yes.
And in terms of the 2009 building code, let's start with that in the original code. What were the exiting requirements for, well, let me back up. Let me ask one question before that. The floor plan which we're seeing here is on the third floor of the building, correct?
Correct.
And what occupancies are we looking at in terms of classifications under the building code?
Right now, with this, that would be B occupancy, and for most of the space. And then there could be an S occupancy for storage, and then some of the other spaces, like for the restrooms and the break room, would be considered accessory, and they would be classified as a B occupancy.
So in 2009, under the 2009 code, under which this building was built, what were the exiting requirements for spaces on the third floor of a B occupancy building?
The requirement is that there be two independent exits.
And can you tell me how that applies? Does it apply to each space on the floor, or does it apply merely to the occupied tenant spaces?
It would apply to all the space on the floor if it's all occupied.
So under the 2009 code under which the building was built, was tenant space A required to have two exits?
Yes,
Tenant space B, was it required to have two exits?
yes,
And was tenant space, or area C, was that required to have two exits?
yes.
And can you tell me what you mean by independent exits?
There must be two paths, egress paths, to the exits. In this case, we have the stairways on the upper northwest corner and on the southeast corner. And those are the exits. They are rated exits. They have a fire rating, and they provide a path down to grade for the tenants here to get out of the building and get to either a safe area away from the building, or if that's not, then they might need an area of refuge. But they need to have two independent exits with nothing obstructing them.
Is there
A path to
anything,
them.
excuse me, let me ask a different question. There was some testimony this morning about those exits only being required during times when the tenant spaces were occupied. Would you agree with that?
No.
What is your understanding of the exiting requirements?
The exiting requirements are required at all times. There is no distinction in the code whether or not what would be normal business hours, because the building code does not address what would be normal business hours. It's not possible to address it because tenants can have varying hours. So there's no way. So it's if the building at any point is occupied, there must be two exits.
And I believe the statement by Mr. Higgins was that the code does not require 24/7 access to two exits from all of the spaces. Do you agree with that?
No,
And why not?
because there are multiple situations that could arise that somebody could be in the building and something could happen and they need access to be able to get to one or the other of these exits. There are multiple situations that we could propose that, and I think you've already brought some of them up, that would refute his assertion.
So, Mr. Higgins, I've been talking about the 2009 code, but I understand that the testimony has focused on the 2013 permits, which would have been decided under the 2012 code, if I understand correctly. Were there any significant changes that you can recall between the 2009 code and the 2012 code in terms of the number of exits that are required or what is required for those exits?
None. I have researched, since this come up again, to verify that my interpretation and what the code is specific on, and there have been no changes from the 2009 to the 2012 or to the 2015.
So the code requirements relating to exiting from spaces on the third floor of a B occupancy building have remained the same throughout the life of this building, correct?
Correct.
What does the code provide with respect to whether or not there can be a locking door that a person must go through in order to get to one or both of the exits?
The code does not allow a locking door in this configuration. Does not allow a cross-corridor locking door, period.
And can you tell me why that is?
Because of the situation that could arise where somebody could end up becoming trapped, especially in Area C, and they could be trapped in there, and if we had a situation that arose in the stairway where they were not able to access through there, and they can't get back through the door that is going into tenant space B. Like I said, they're trapped, they're stuck.
Well, but Mr. Hinton, the testimony was that the doorway into tenant space B would remain unlocked and open during business hours. Wouldn't that satisfy the ability to get to an exit from area C?
No, because there are multiple other potential situations where somebody could be in there after business hours. And what are business hours? Various tenants can have different business hours. And the code does not address that. And the code specifically does not address it because you cannot, through the code, establish what a business hour is.
Now, Mr. Higgins also testified, though, that people like the tenants would all have keys to their spaces. The clients would all be able to access through those spaces because the doors would be unlocked during regular business hours, and cleaning crews would likely have keys. Why is it an issue then?
Well, I can follow up on something that you brought up. We could have a client who could be visiting either of these tenants, and they could exit out of the tenant space. They could be in area C, and the door there could end up being locked, and they wouldn't have access to get to the southeast corridor. There are a number of different scenarios where that can come up. Then the other question that I would propose is, who has control over that doorway? Who controls it?
And why is that a relevant question?
Well, we could have a situation where tenant B controls and locks that door. Tenant A, something could arise where somebody goes out from their space into area C. Their doors remain locked even during business hours. Let's say they're working at night, and I'm just gonna throw out, if you had a tenant in there who worked all night, let's say a sleep center, they have to stay specifically in their area. They don't monitor everything that's around there, and one of their clients goes out. Their door automatically locks behind them. Something happens in one of the exits, especially in the northwest. They can't get back into tenant space A. They can't get through the locked corridor that leads into tenant space B. They're stuck there. Tenant A may never even know that there's somebody is trapped out there.
So, Mr. Hinton, I think we established earlier, but let me just go through this with you. With respect to tenant space A, if someone is inside tenant space A, do they have access to two exits?
Yes.
And if someone is inside tenant space B, will they have access to two exits under this scenario?
Yes.
So, and then what about tenant space C? Do they have access to two exits within your understanding of the building code?
No.
Now, you mentioned in your, there is mentioned in the decision that you provided to Mr. Moe, there is mentioned some building code commentary. Do you recall that?
Not specifically, I'm sorry.
What exhibit?
I am looking for the exhibit number right It is Exhibit A7. Exhibit's A7. Do you recognize that exhibit?
Yes,
And is that an exhibit that you and Mr. Lawrence sent to Mr. Moe as your decision on the locking door?
yes.
And I'd like you to turn to page 3. And there is some language there about locked doors. Do you see that? Both on pages 2 and 3.
Yes.
There are language about locked doors. What is your understanding of when a locked door can be placed in a building?
There are very specific provisions which are noted here under 1010 1.1.9, and they spell out these areas that can have a locked door. They also, this also leads into like the main egress door, which has to be on the main floor. These provisions do not apply to third floor and this situation.
And is that why in the commentary that is set forth in the middle of page 3 that it says that the locking arrangements are not permitted on any door other than the main exit?
Correct.
And as far as your testimony that about the code changing between 2009 and 2015 during the life of this building, has the code changed with respect to that exterior locking mechanism provision?
No.
So this would be the same in 2009 and in 2013 and in 2015, correct?
Correct.
So let's turn to Mr. Reithner's actions in 2013. Do you understand that Mr. Reithner approved this doorway,
Yes.
this locking doorway?
Yes.
If he did so, would that have been in error?
In my opinion, yes.
Now, Mr. Higgins testified about the ability to approve this as an alternate based on this provision in the code about locking devices on the main door. Do you believe, have you seen any documentation that indicates that was Mr. Reithner's thinking?
No.
If that was Mr. Reithner's thinking, would that have been correct under the code at the time?
No.
And why not?
The code is very specific as far as this situation, that what can be allowed. In this scenario, a corridor doorway is not allowed in any of the codes, 2009, 2012, 2015. The only door that would be allowed in this scenario would have to be part of a horizontal exit. And that is a 2-hour rated assembly, which literally, by code definition, separates the building into 2 separate buildings. Then a door could be allowed, and that door would have to be also part of the rated assembly, and it would have to have at least an 1.5 hour fire rating on it. That door cannot be locked.
And is that horizontal exit, is that something which is shown on these plans?
No.
So if Mr. Reithner approved that locking door, that would not be allowed under the scenario that you're talking about, the locking mechanism on the exterior door, correct?
Correct.
And there is no internal access corridor of the type that you're talking about with the fire rating.
Correct.
So are there any circumstances under any of the codes that we've been talking about under which that particular mechanism would be allowed, in your opinion?
No.
What about the alternative provisions that Mr. Higgins talked about the building official having the authority to approve some alternative to the code?
The building official does have that authority to approve alternate methods and means. Those approvals cannot be less restrictive than the code. And in my opinion, providing this alternate means, one, is less restrictive. It impacts egress and safety. The second thing about it, with a horizontal exit, there is no security provided to tenant space B. That door can't be locked, or doors. There's no provisions for it to be locked.
So in your opinion, can the building official approve that? Could the building official have approved of this as some sort of alternate mechanism?
I don't see how.
And it was talked about during the testimony of the appellants that Mr. Reithner obviously made a, quote, interpretation, unquote. What do you understand the building official's authority to interpret the code to be?
The building official does have the authority to take and review alternate means and methods. Those alternate means and methods must meet the intent of the building code, and or they can either meet the intent or be more restrictive. They cannot be less restrictive.
And can the building official make an interpretation of the code when the code specifically states a particular thing?
In my opinion, no.
Now, the 2018 plans that we are talking about only partition off offices.
Correct.
Is that door being altered in any way, the locked door, by these 2018 plans?
No.
So why are you concerned about it now, since there's no proposal to alter what is already there and what was apparently approved by Mr. Reithner?
First thing, Mr. Reithner allowed this in error. Second thing, by allowing this, we have made the building less safe than what the building code requires. With that said, underneath my authority as a building official, if there's been an error that has been made, I'm granted the authority to rescind that decision, to bring the building into compliance and bring it up as far as safety is concerned in this situation.
So do you understand that you have the authority to require even existing buildings to be changed if a safety issue is involved and there is a permit pending before you?
Yes, and that is supported by both the International Building Code and also by the IEBC. That if the building was constructed in nonconformance with the code, it is not allowed to remain just because it was approved in error.
Did you, in making your determination that this did not meet the requirements of the code and needed to be corrected, did you attempt to confirm your understanding of the code by consulting with others?
Yes.
Why did you do that?
I wanted to gather other perspectives, make sure that my view was correct. Having others, which I could discuss this with, gain other perspectives, and I can make errors, so I want to talk with others, make sure that just my thoughts, my interpretation are appropriate.
So you consulted with others in order to make sure you were right.
Yes.
And who did you consult with?
I consulted with Mark Lawrence, the fire marshal. I consulted with James Gray, who's a plans examiner. I consulted with another plans examiner on staff here, Von Kersey. I consulted with a number of other building officials, which I know, and ultimately, in the end, I contacted ICC and spoke with one of their technical code officials to verify that my interpretation of this situation was correct.
And did you receive from any of these individuals any information that your interpretation was incorrect?
No.
Is the document, which is Exhibit C3, was that prepared by you? It's a document
Yes.
that is dated 4/19/19.
Yes, this was prepared by me after, literally, while I was talking with the ICC technical representative, I took notes, and immediately after I got off the phone with him, I wrote this up immediately afterwards.
And so this is a summary of your conversation with the ICC official?
Yes.
And did the ICC official confirm your interpretation of the code?
Yes.
If the placement of the locking mechanism on this door remains, would you consider this to be a safe situation for those using Area C?
No.
And why is it not safe?
Doesn't, if the locking mechanism is on the door and the door ends up being locked, people using C may not have access to the southeast exit stairway.
And what would happen in that case?
Well, if we had a scenario where we had a fire in the northwest exit, they're trapped. They don't have a means to get down to the southeast stairway. It could be a situation where somebody is going to be put in a situation where they could lose their life.
Mr. Hinton, there was testimony by Mr. Higgins that this is a commonly occurring type of situation, and that other jurisdictions have perhaps allowed an interlocking a system that interlocks the fire alarm system with the locks on the doors. Are you aware of that occurring in the city of Issaquah?
No.
Has it ever occurred in any of the jurisdictions which you have worked for?
No.
Are you aware of any jurisdictions which are allowing this?
Personally, no. By testimony by Mr. Higgins, he says it's happened, but personally, I don't know of any situation where this has been allowed.
Is this something which ordinarily you would make the call on, or is this something that Mr. Lawrence would make the call on as to whether this was allowed?
I would make the
Did you review the applicant's proposal to do such a interlock in this particular case?
I did in consultation with Mark Lawrence, the fire marshal, and we also had discussion with James Gray was part of the discussion, and Lon Kersey, and I spoke with other building officials that I know about this potential situation. And in each case, the answer was no.
Does the city of Issaquah have any amendment to the building code which specifically allows this type of interlocking fire alarm mechanism?
No.
I assume you've seen the exhibit that the appellants presented with a Seattle code provision that allows that. Are you aware of any other jurisdictions who have that particular code provision?
No.
Is there anything else that I haven't asked you about, Mr. Hinton, that you would like to comment on and make sure the examiner has background on for making his decision?
The decision that I made to not allow the permit, there was a lot of research, a lot of time spent looking at this scenario, reviewing the codes, and discussing alternate means and methods to this. And we couldn't find, and I couldn't find, anything in the code that specifically allows this.
So is it your understanding, Mr. Hinton, that that this door needs to be changed in order to meet the code?
In actuality, the code does not even allow a cross-corridor door, period. And if you go on that basis, it would need to be removed.
I have no further questions for this witness.
Give me just a moment.
Sure, I'm gonna ask one that I have, you know, I have the discretion to ask questions. I fully understand your view that the previous building official erred when you approved the 2012, 2013 plans. Do you believe you erred when you approved the 2018 plans for Tenant A? Because I guess I'm confused as to why this situation here is any different, or that problem is any different than what exists over here. So is the view that there was an error in 2013, there was an error over here, and now we're fixing it now that we're looking at this? Or you think that situation is totally separate from this situation?
I think when the two offices that were added to tenant space A, and that this door wasn't addressed at that time, was a error. But at that time, when that was being approved, it wasn't brought to my attention. I do not do every plan review that comes into the office. My opinion, my thought is that how that was approved was, there was a mistake by the plan reviewer who approved that. And when the inspections were done, that cross corridor door was allowed. Also, I've spoken with the inspector who did the inspections for the previous tenant improvements. He did not realize at the time when he was doing inspections that that door was not allowed.
So we've sort of piled on over time, is
Yes.
what it sounds like.
Right,
Okay.
right.
Well, thank you for clarifying that. That was the big question I had. I'm going to let you do your cross now.
I think you took my thunder on my first question.
So, well, you're trying to convince me, so if I have the question, then,
Well- I'll hold my comments till the end. You had testified that, and you used the words adding space with regards to this. When Counselor asked you about you permit for tenant space B, you used the word adding space. That was your testimony, quote unquote. In your view, what space was added in B?
In B, adding space, from my review of the records that we had, that wasn't an occupiable space. We had tenant A, which had their area. We also had the common area C. We didn't have a tenant in there. So that area, from the information that I found, was not an occupiable space. So the space that is being added now is occupiable space.
Okay. At some point in this process, you were made aware that that space was occupied. Were you not? And it had been occupied since 2013.
Who made me aware of that?
Through all of this paperwork and those
Okay.
plans.
This information from talking with the fire marshal, and he is the gentleman who did the inspections there, talking with the building inspector who did the inspections there, checking with city records. Prior to this application in 2018, all the information that was provided to me, there was no occupant in there.
And I understand that your research, based on what was available to you internally, said that that was never occupied.
Okay.
Through this process, not only here today, as testified to by the architect who designed it, the plans submitted and the plans approved, it was occupied. Are you disagreeing with that statement, that it was occupied?
Well, my question would be, was it legally occupied? If I don't have specific information showing that it was legally occupied,
Well, you approved plans for the space to be segregated in 2013.
I wasn't here in 2013.
Okay, I'll ask the question once again, because you didn't directly answer it. We've had testimony today that that space was occupied beginning in 2013. Which has basically been uncontroverted. Yes. Yes, it was approved. Does your opinion about the door in question, because it's really all about one door, the door in question change knowing that it was occupied and based upon the provisions in the code that talk about, that refer to prior existing space and continuing on with the improvements as permitted?
With the scenario that you're just proposing, that door should not have been approved with a prior occupancy.
And that was your testimony late, and I don't mean, I shouldn't jump ahead, but you made the statement that you think that door should not exist.
Correct.
And it goes right to what the examiner said, which is, why wouldn't the door to A also have to not exist?
You're talking about the one on,
It's this door.
okay,
We see this door and that door as being the same kind of door. They both would you not agree, give access to, we're calling it the C space, the common area?
No.
You see those doors being different?
Yes.
Okay, please explain why.
We have an.
Do you want it?
Sure,
Or you come
I'll
stand
walk
up.
up here. This area basically is an egress corridor. And that provides access to here, but we also need to have access to here. A tenant and the occupants in here, none of this area in here is considered an egress corridor, egress access. So the fact that the tenant can come to this door and either go this way, or that they could go down this way, or if the door wasn't here, they could come out and go like this, if this door wasn't there. This door becomes an impediment to egress access to here, specifically, depending on the scenario that could be provided. There are a number of different scenarios. So this door is not the same as this. This is a corridor. This is a cross corridor door. And this needs to be able to provide access to both areas.
So it's your testimony that there must be corridor access between both points of egress?
Yes.
Does it say anywhere in the code that there must be corridor access?
Yes.
And what section of the code is that as it relates to the building at this time?
I know it's in chapter 10. Off the top of my head, I don't know if it is in, I'm gonna look at, I may have referenced it in C2. Yes, and it's in italics.
What page?
What exhibit?
Exhibit C2,
Two.
and it says two passive egress.
What page?
First page,
Oh, first page, okay, thank you.
first page. Two passive egress are required from any point on a floor. Corridor shall be maintained between stairways. Doors in corridor shall not be locked in any manner. Building owner states that this door will not have a lock. Specifically, yeah, we'll have a lock. Specifically, in the code, a doorway, a door is not allowed in a corridor. Specifically, there is no provision that allows a door in a corridor in this situation.
Now, you heard Mr. Paladar testify that his job is to design a building consistent with the code, okay? Is anywhere on the original plans or anywhere else, is anything past that door labeled a corridor?
No, because,
Okay, is a corridor a defined term in the code?
yes,
Okay. Is space a defined term in the code?
I would have to go and look at definitions. I think space is defined in the code, but I'm not sure.
I think I remember.
I gotta ask you a question because I'm so lost.
Okay.
I thought you were going to direct me to code language, but what the italicized portion you read just now, those are just comments from Fire Marshal Lawrence, right?
Yes,
Yes,
So that isn't a code provision.
correct.
So I have not yet seen a code provision that you were asked to reference, is that right?
Correct.
I'm totally lost.
No,
Okay.
no, you are 100%
Okay,
right.
good. I just wanted to make sure I didn't miss something.
we could take the time and probably look it up.
Why don't you do that?
Okay.
We can have a moment.
10.26.
You can't do it because it can't pass through the joiner to be except for accessory.
10.08.3.1. It's the meeting spaces. It's got the corridor. The one that you quoted is right here, Mark.
Where's it at?
10.08.3.1.
10.08.
3. Excuse me. No, this is it. It's a fire resistance rated corridor.
As I say, if the answer is yes, since you've been tasked with getting the code, you know.
Yep.
Okay.
We found it.
Okay, and, yeah, he's fine, he's not here. Go ahead.
10.20.6 corridor continuity. Fire-resistant rated corridor shall be continuous from the point of entry to an exit and shall not be interrupted by intervening rooms where the path of egress travel within a fire-resistant rated corridor to the exit includes travel along unenclosed exit access stairways to ramps. The fire resistance rating shall be continuous for the length of the stairway or ramp and for the full length of the connecting corridors on the adjacent floor leading to the exit.
Okay, I'm sorry, you said
Okay.
the code number too quick for me, sorry,
10.20.6.
20.6. Okay,
That's the
Also-
IBC or the IEBC, or IBEC?
IBC,
IBC, okay.
also exit access.
Go for its tenant space B to get the
Right.
second exit.
10.16.2, egress through intervening spaces. Egress through intervening spaces shall comply with this section. And is it 2? What are you recommending me to read? Okay,
So
yeah.
they can't go through an intervening space.
Right.
when-
Exit through an enclosed elevator lobby is permitted. Access to not less than one of the required exits shall be provided within travel through the enclosed elevator lobbies required in section 3006.2, 3007, or 3008 International Building Code, where the exit path of egress travel passes through an enclosed elevator lobby. The level of protection is required to be enclosed in an elevator lobby. Number 2, egress from a room or space shall not pass through adjoining or intervening rooms or areas, except where such adjoining rooms or areas and the area served are accessory to one or the other, and are not Group H occupancies and provide a discernible path of egress travel to an exit.
okay.
If you enter into another space, you don't have.
Oh, yeah.
Mark, you
Yeah,
have to wait.
Yeah, okay, it's okay.
We'll get there.
We are trying to get
I
there.
apologize.
I'll ask the question again, though. You read the definition and it said a corridor cannot have a locked door. And that is for the purpose of allowing a person to go.
No, the corridor, to be clear, is not allowed to have a door.
Okay, I apologize. A corridor is not allowed to have a door. And a corridor is defined as what?
It is a means of egress path to the exits, to an exit. In this case, because it's the third floor, we need to have 2 exits.
So-
Also, one other thing has just been pointed out to me, which I didn't read. An exit access shall not pass through a room that can be locked to prevent egress. That is 1016.23.
And that goes back to, you would like to see a corridor that travels from this stairwell to this stairwell, correct?
We need a continuous path of egress between the two.
And this is the crux of this entire issue, which is this common area accessed by tenants, A and B, as well as the people who come to visit them, or, whether this space is being occupied at the moment, or after hours, or not occupied, the people who are utilizing this space are there for the other tenant. Are they not?
Not necessarily.
Who, admittedly, because I tell my clients, we could play what if until you spend $50,000 of your money and I answer each one of your questions. The reality is, this is an office building, correct?
Yes.
The people who visit office buildings are the people who work there and the people who come to those businesses, correct?
Not necessarily. We already pointed out that cleaning crews and
Do they not?
other.
Do they not have keys?
Shall
I mean,
throw-
this really is-
Shall I throw out a scenario where they
No.
don't have a key? What if we have a separate cleaning crew for A and a separate cleaning crew for B? The cleaning crew for A would not have keys for B.
But they have keys for A, so they are either in or can pass through to this corridor. Let me ask you this question. Is the code's intent to deal with every possibility that could ever exist?
The code is to take a look at all the potential possibilities.
So,
That is what,
I'm
that's our
I'm
job.
gonna ask you to answer that, yes or no?
Yes,
The code's intent is to deal with every possibility that could ever exist.
so if the lock breaks and I'm in the bathroom and the lock breaks on the bathroom door, I'm now stuck and I don't have two egress points, right? Because I'm stuck in the bathroom. I guess the theoreticals are killing me, and this is gonna last for 7 hours. I'm still stuck on how this situation is any different from that situation. You've told me the corridor is the difference. So if you're saying, if this just kept going all the way and the door was on a north-south access, then it would be the same, but because the door is on an east-west access, it's somehow different than this situation? Or this was a mistake the whole time, this shouldn't have been approved, this shouldn't have been approved, this shouldn't have been approved, the city finally figured it out here. Really, there isn't a difference between this problem and this problem. I just don't fully grasp.
exactly. What
No.
your latter comment was, this was an error when it was initially approved.
But even here, you made an error in 2018 in approving this, right?
Could have been. I never saw this, but it was approved through us.
Well, let's just say,
So-
whether
so
it was
let's-
you or the
let
city,
me-
what they're saying was this.
Wait a minute,
Can I finish?
counsel, if you want to argue with my client, you can argue with him afterwards. If you want to let him answer your questions, you can let him answer your questions. But I'm not going to let you do that right here and argue with him.
I was actually just gonna clarify whether it was him
You
personally.
can wait for him to finish his questions, finish his answer,
I'll take
and
a
then you
breath.
can ask him a question.
Okay, what was the question?
My question was, right, because I was asking the question, my question was, I still, to the building official, I still am having a very difficult time understanding how there's a difference between this and that, and between this proposed, not proposed, this pre-existing door, and that pre-existing door that leads into the tenant A space. So, I'm trying to, again, I could wrap my head around there was a mistake that occurred in 2013 that we're now trying to fix. But what's new to me today is the idea that somehow this was approved in 2018, and then a couple months later, this wasn't approved. And it sounds like there was an oversight issue here that's been the same problem all the way through, and it's the city's position that that's a mistake, that's a mistake, that's a mistake. We finally realized it now, and we're trying to fix it. Is that an accurate characterization?
That's an accurate characterization of what the situation is.
Okay.
And
I think you
Going back
answered the
to this-
question.
Let him just,
Okay.
I want to hear the end here.
Okay.
So just,
Going,
I'm a lawyer too, so I'll try to, it's going to take forever with three of us in the room, but just let him finish.
and going back to discussing like tenant space A, in their space, they do have access to get to the two exits.
So does tenant B when they're in their space, right?
No,
I don't.
I'm sorry, please point out how they don't. This is the crux of this position that we're all spending a lot of time and money trying to answer, which
Okay.
is,
okay, I'm just gonna give you a personal observation that we have in this building here.
okay,
As you came in here, if you didn't come upstairs, but if you came down through past where the permit center was, went down past the bathrooms and went to the door back there,
okay,
that door is locked,
yes.
okay?
Or just employees only or something, I'll assume it's locked.
But it's locked. Here's the problem, and this has happened multiple times since we've been here. There have been employees who were here, and just on Friday, the situation happened. We had an employee who had gone to use the restroom, came back, and left their keys on the desk. They weren't able to open that door. I happened to be walking out and opened the door for them. So even with this, the situation where you could have tenants here, there's potential that somebody in B leaves their keys in their office, goes out, and something happens. They can't get back in. They're stuck in that corridor. You have occupants,
We will concede that point.
okay?
Same thing in my office building. You walk up the stairs. If a fire happens below you, the door is locked. I cannot access the other exit at the other end of our tenant space. I mean, you are absolutely right. You can create a scenario, and in this case, where somebody locks themselves behind. I guess, not that I guess you did testify to this.
Is
Is
there a question?
Yeah.
Yes, Mr.
Well, again, I
Your
swear to
brain
God.
hurts, I get that. I don't know if we're making progress.
Well,
So I think we're stuck spinning our wheels. If you have a question you think will move it along, great.
Let me,
But I think my understanding of the situation, which is ultimately I'm the one that has to make a decision here, it's not, let's try to win an argument on the details right now. I'm trying to understand the situation. If you have a question that'll further that, go ahead. If not, I just think we're
Is there-
spinning wheels.
is there anything that could be done to this, and I mean anything, to this space? And I don't mean A or B, I mean the third floor, that could make a person or allow a person to occupy this space?
Which space are you talking about?
The
Occupy?
whole floor is what I said.
Okay, A is already okay as far as being able to occupy it.
Oh, okay, that wasn't quite my question. So I'm trying to literally,
If you would let him answer, I believe he was going to answer your question. If you would let him answer.
well, I'm not talking about A, which is what he immediately went to.
You asked for the whole floor.
Yes.
Sir, so give him a chance to answer your question, and then if you have more questions, fine,
Okay,
give him a chance.
B, there are paths. C, there's only one.
okay, that didn't answer my question. What could be done to this space that would allow the entire floor to be occupied?
The whole space?
Whole space, C, B, A, whatever you want to call it. The third floor.
Remove the door.
Then somebody's going through tenant space A to get to the, that's against the code.
This isn't going through tenant space A. Going this
Excuse me,
direction
B,
doesn't go
I
through.
apologize. Then you're going through somebody else's space
Right.
to get to that door, and you said that was
Create
against
a
the code.
corridor.
So, create a corridor.
Yeah,
Could you put a door right here?
no,
Why?
because that would block access to the stairway
For who?
for both occupants.
A non-locking? There's only one occupant on the floor.
Okay, so we
So
only
this
have.
is all occupied by the same person, again?
Oh, okay.
And you
So-
put a
so-
door right here.
So the scenario changed now. All
No, it's
occupants.
my, same question
Okay,
I asked, which is,
okay.
what can you do? You answered one, put in a corridor. I think we already knew that was what your testimony was. So my next question is, if you put a door right here, so that whenever somebody came up these stairwells and ran into a door, would that be code compliant?
Which direction are people egressing?
Will they go out the door to get to this, or the elevator?
As far as code is concerned,
Yes.
you're not allowed to have a door in the corridor on the third floor. So, we have, if this is all one tenant space,
Mhm.
but we go and block this exit,
Who would we be blocking?
anybody coming out this direction,
You guys can maybe talk about this
No, no,
another
no.
day
No, no,
on
no.
your own
No, no.
time, because it doesn't seem to benefit
Oh,
the
and-
decision maker in any way, shape, or form. I can't even see what you're pointing at right now.
The answer is that he clearly will only allow this space to be occupied, especially with this build-out. Of course, I'm fearful that they're gonna say that this space is gonna be condemned or something by demanding the corridor between the two stairwells.
Okay, that's the point you're ultimately making.
No, I'm actually there is an alternative, but I offered and asked, why couldn't a door be placed there?
Sure. Okay.
And you immediately said it was a corridor, and therefore you can't have a corridor, even though this could be essentially a door to a single tenant, nobody would ever pass through it, except the occupant.
Are we making argument here, or are we asking a question?
Well, yes, I am making a bit of argument in the process that we have been going around in circles for months over this little issue, right? Here we are.
I believe the hearing examiner has what he needs in order to make his decision.
Right.
I'm asking you to either ask a question or save it for argument.
When you said that Mr. Reithner made an error, would you also say he was negligent? Would you use that term?
no?
So how is he not negligent?
Are you preserving this argument for
No,
future
they don't.
lawsuit? Because
Yes.
I am not loving where this is headed right now,
I'm
because
gonna
I
object.
certainly don't have the authority to make that determination.
Oh,
so-
we wouldn't have asked you.
Okay, but
I'm asking-
I'm gonna sustain an objection. I don't even want to go there. but
Okay.
Calls for
It's
legal
on the
conclusion.
record at least.
I'll just clarify that my objection is that it calls for a legal conclusion in this.
Sure, we could have gone with scope. We
It's
could have
not
gone with a lot of
a
things.
lot
I'm
of
gonna
things.
sustain it on every ground I can think of, so.
Sounds good to me.
When you said you called other, and spoke to other people about the interlocking system, did you call other jurisdictions?
I called building officials in other jurisdictions, yes.
Who did you call?
I called a gentleman by the name of Terry Knox, who works for a consulting firm and also is an acting building official through his company. I have gone to MVP, which is mybuildingpermit.com, and that is a member of a group of building officials, and I brought this up in one of our meetings, and we discussed it there. I talked with a former deputy building official, Ed O'Reilly, who I worked with under a number of years when I was in Stockton.
Oh, okay.
And
Did you call anybody around here? It's been testimony that Sammamish, Kirkland, Seattle, a variety of jurisdictions locally permit the interlocking system.
we have contacted Bellevue, and we haven't heard back from them. One of the building officials that I talked with is the building official for Sammamish.
And he said they don't allow it?
That was the comment that he, in the discussion that we had, he wouldn't allow it in this scenario.
Well, doesn't that all depend on how you factually present the scenario?
I provided, and I know an accurate,
Did you provide a copy of the plans?
no. But I drew a copy of the plans.
I'm in arrest.
Okay.
Do we even need to have Mr. Lawrence testify? I mean, I think we all know what the issue is. Obviously, you're allowed to do whatever you want to do. But
Just deep breath, Mr. Essig. Did you have any redirect, Mr. Haney, based on that?
I don't.
Okay. Again, I just want to stress, I really understand the issues, I think. I'm not saying I understand the reasoning on it by either party. I'm not making any kind of rulings right now. But again, I know we've been talking about a door for about 4 hours. This has actually taken longer than the entire expansion of the light rail and Snohomish hearing took a month ago. But I want to give you an opportunity, Mr. Haney, to bring any other witnesses, including Mr. Lawrence, to testify, but brevity would be appreciated.
I will do so. I
Okay.
will call Mr. Lawrence, but just for brief testimony.
Thank you. Mr. Lawrence, do you swear or affirm to tell the truth in testimony you give here today?
I do.
And just so I don't screw this up, is your first name unusually spelled with a C and a K?
M-A-R-K.
M-A-R-K.
Correct.
Okay, we had it wrong on the witness list, so I'll make sure that's correct on the final decision. Thank you for being here.
Mr. Lawrence, would you please state your full name and your business address?
Mark Matthew Lawrence, 175 Newport Way Northwest, Issaquah.
And what is your current occupation, Mr. Lawrence?
Assistant Fire Marshal assigned to City of Issaquah.
And what are your general duties as Assistant Fire Marshal?
Fire inspections and plan review of new construction, as well as occasional existing construction when there's a need to have an oversight, if you will, from the company level inspections.
And you're with Eastside Fire and Rescue? Do they contract with the city for these services, or how does the city receive your services?
Not so much a contract, it's a partnership agreement.
Now, you heard Mr. Hinton's testimony, and I'm not going to go into it in great detail. Is there anything you want to add to Mr. Hinton's testimony with respect to the, whether or not the 2 exits are required from every space?
Well, the code is very clear. In this case, it's black and white, it's not an interpretation. 3rd story and above needs 2 exits. You cannot have 1 exit. It's not 2nd story, it's not 1st story. 3rd story and above, it's very clear in the fire code and the building code. An accident is one discipline that is in both codes because it is so important to be able to get out of a building. And the code makers say 3rd story and above, it's black and white, it's not interpretation. You need 2 exits. You can't have 1, you can't do it. That was my original issue with the way this permit was submitted. I went to Mr. Gray, I went to Mr. Kersey, I consulted with both of them. Hey, am I missing something here? Because we do sometimes. When they said, no, you're right on, both of them, I presented it to Harry, and the correction was written, and here we are today. So bottom line is, it's not permitted. It should not have been permitted way back when. And as code officials, you know, safety of the citizens and the occupants of the building and their customers, want to make sure they can get out. for a reason, and that's my job, is to enforce that code. Here we are.
Mr. Lawrence, do you, I guess maybe I should call you Marshal Lawrence, but.
Park's fine.
Okay. Is there, do you provide fire marshal services and fire code, the same types of services you provide for Issaquah? Do you provide those for other jurisdictions?
We do. I'm also assigned to City of Carnation. We have another assistant fire marshal assigned to North Bend and Sammamish. In addition, we take care of King County Fire District 38 and King County Fire District 10 in terms of suppression, EMS, and also annual fire inspection, but not new construction.
And are you aware of any of these other jurisdictions that you or Eastside Fire provide services to that allow a locked door under circumstances similar to this? There was some talk in the earlier testimony about some sort of system that interlocked or was tied the locking mechanism to the fire alarm system. Were you here for that testimony? Did you review that proposal made by the applicants in this case?
The proposal was brought forth in an email fashion, and I did not think it was relevant to this situation. Any sort of locked door, again, the code does not allow a locked door. In any case, if that was the reason for a locked door, a sensor as you approach the door should unlock that door by code. So what's the point of locking the door?
When you say a sensor should unlock that door by code, which code are you referring to?
Oh, I'm sorry, Chapter 10, Fire Code and Building Code.
So if there is a locked door, the fire code requires that there be a sensor that would allow it to be opened?
In certain applications, yes.
Is there anything in the fire code that you know of that allows this type of proposed system where you tie the locks into the fire alarm system?
Yes, you can have these locks tied into typically main exit doors that would unlock the fire alarm. In addition, there would be a panic hardware that would require the door to irrevocable action once you hit the panic bar. Release in 15 seconds for loss of power or activation of fire alarm would immediately open that door.
Now, you mentioned
It's
that was available in a main exit door,
No, secondary exit door.
secondary exit door.
Exits outside.
Would that qualify, would this application qualify for that?
I don't believe so, no.
Now, when you reviewed the proposal made by the applicant for this interlocking system, did you indicate to them that you had made a decision regarding it?
I don't recall what I put in my email. I'd have to look back at that exhibit.
Did you say you emailed them regarding
Correct.
this?
That was one of the, there were several proposals, several different emails. Each time I found the code and the commentary to it and addressed it. I don't ever actually said, can't do this, or maybe I did. I'd have to look back.
And your experience as a fire marshal, is this something that you would find acceptable?
On a cross corridor door?
On a cross corridor, on the door in this situation, I'll avoid the use of the term, but in a door in this situation, under these circumstances, would you find that type of system acceptable?
No, not this particular door, no.
And why not?
My research shows that you cannot have any locks on an exit door. You potentially could on the actual door into the stairwell, because once you get into a rated stairwell, you're considered in the exit that will bring you outside. So if we had panic hardware that might have 15-second delay on it, and I'd have to double check the code for B occupancy. We don't get that question too often. That's potential because you're already.
Could you speak up a little bit, Marshall?
You're already going out, so.
I think people are asking you to speak up because they
Okay.
can't hear you, so if you
Sorry.
could, just a little bit.
Sure.
Are there any circumstances you can think of under the fire code in which this particular door could be allowed to be a locking door?
No.
Do you consider this to be a safe situation?
No. Absolutely not.
And why do you say that?
As I stated earlier, egress is the number one, in my book, the number one code issue out there. You have to be able to get out of the building safely. And if that door's locked, something happens. The attorney's in there in Unit B, and it's 7 o'clock at night, and their client leaves, stops in the restroom. That attorney goes down the southeast stairwell, gets in his car and drives away. Everything's locked up, Tenant A is locked, something happens to the northwest stairwell. It's not access to exits. It's prohibited.
Is there anything else that I haven't asked you that you want to add in this, in your testimony?
Yeah, I had one issue on the cartel drugs one time in Sammamish. For 9 a.m. the store opened. I went in at around 10 to look at a tenant improvement, I believe in the pharmacy area for some sprinkler heads. And on my way out, I noticed that the required secondary exit further back in the store had a locking arrangement on it with a padlock. And I went to the manager. She said, "Oh, I was just getting ready to unlock that." This is the reason that secondary exits cannot be locked, unlike the main exit that can have a deadbolt with the sign above. Required secondary exits cannot be locked, just for that reason. The deadbolt on the main exit, if the store wants to be open, that main door is going to be open. That deadbolt will be open. What's to prevent someone from not unlocking the secondary exit? Something happens up front in terms of, in case of that Bartell drugs, people would not been able to get out. There's not allowed to be any locks on that secondary exit. This back stairwell is a required secondary exit, and in my view as a code professional, it cannot be locked.
And I'm sure Mr. Essig will ask you, so I will ask you. The 2018 TI for Tenant A, were you involved in that?
I'm the one who made the original comment. Oh, Tenant A. No, I
Tenant
did
A.
not do the review on that. I did the inspection on fire sprinkler heads only. That's the only reason I was there.
So you don't know why that was approved without requiring the access door to be unlocked?
No, and quite frankly, I wouldn't be looking for that, just going in to look at fire sprinkler head placement, distances, that sort of thing.
No further questions.
Thank you. Any cross?
Yes, I'll be very brief. A15. I'm gonna say page 12. If I had to count myself, just. Second page in from the end. Oh, it says on the bottom, 12 and 13. About 3 fingers down, it says fire, Mark Lawrence, approves. Is that correct?
That's what it says, yep.
And going back to the very, very first page of Exhibit A, what was this for? Or I'll ask the question, was this for the original building plans in 2011, 2012?
I'm not sure.
It's permit number BLD 11-00135. Applied for in 4/15/2011, finalized in 10/31/2012.
Mark, you need to look at
document.
I'm trying to find out where he's talking about.
A15.
Right, front page, you said?
Well, we'll start with front page to identify what we're looking at, but eventually we're going to look at page 12 where it has your name as approving the corrections and therefore approving the plans, I would assume. Your name is also just below that for approving something else, but I was going to ask you, what are you approving?
I can barely see this. Well, it's possible I did look at it and just don't recall. I do approximately 600 plan reviews a year. That's quite a bit since then.
Okay, since everything's written in what I would call code, what are you approving? As I said,
Like I said, I can't see this very well. If this actually is the building plan, then I'm approving it for fire sprinklers at that time and fire alarms to be updated. Fire was not technically looking at exiting at that point in time.
why was that?
It's just the way it was. It's in the building code was doing it. It's in the fire code, fire was not doing it. Somebody was looking at it.
So-
Now we both look at it.
Oh, okay.
Yep.
Okay. Then who would have done it at that time?
I assume Tom? Who did it? Ron? I'm not sure. Or an outside consultant.
Okay, quick question, just as this is typed in here. Is the note section above for you or the note section below? Because again, I'm not trying to catch you in anything.
I think the notes are general to everybody, if I'm not mistaken. Any comments I had would come as a condition.
So at some point, I understand you may not have been looking, is it your testimony that you were not necessarily looking at that door when you looked at these plans?
In the 2011?
Yes.
I don't know. I was not specifically looking for the doors.
And who is Jeff, I'm going to pronounce it Werre, W-E-R-R-E?
One of our other assistants. It's possible I may be on vacation. I'm not sure.
I asked that who he is because Jeff Werre's name is all over the permits for tenant space A in 2018.
Okay.
Does that make sense? 2018?
You mean that one?
Yes.
Okay.
Oh, okay. Yeah, he must have reviewed it then.
And somebody from the fire department would have reviewed the plans, as you just testified.
Fire sprinklers and fire alarms, yes.
Well, but by 2018, I thought you just testified that the fire department now looks.
We do.
Why-
Oh, I see, yes.
Why wouldn't somebody have looked at this?
Yeah, I see what you're saying.
Oh, that somebody did?
Should have, yeah.
Oh. Now, just clarification, when you were talking about like the Bartels issue, were you would you have been talking about this door? A door to a second exit?
Right, but a totally different configuration. This is a big box store.
Yeah, I understand, it's a single tenant, well, maybe not, sorry.
Yep, single tenant, big box store, stockroom, typical Bartel drugs.
They got one entrance in the front and a second one in the back, I'll call it.
On the side, yes. The sales floor,
And that is not allowed to be locked,
correct.
except at night?
Nope.
Never. Is it a mechanism where, I call it the paddle, where you push and it opens from the inside?
Correct. And the reason stated it's never allowed to be locked 24/7, in my view, is just the reason I stated that manager came in, forgot to pull the padlock off of a secondary exit. The front door is gonna be open, this door to remain unlocked with a deadbolt on it because they want customers to come in. They don't necessarily think about the second exit.
Is it locked from the outside?
Correct.
Does it exit to the outside?
Yes.
Okay. So a burglar couldn't get in the door?
Not inside, they can let themselves in through the roof if they want to
Or,
through the exit.
I just meant the door. I'll ask you the same question I asked Mr. Hinton, which is, you mentioned about speaking or a lack of knowledge of other jurisdictions that permit the interlocking device, we'll call it. Is it your testimony that other cities in the area do not allow that?
I have not checked with other cities in the area on this particular issue.
Have you ever reviewed plans? Since, let me clarify testimony. You work for a variety of cities?
Correct.
Okay, have you ever reviewed plans that called for an interlocking door?
Not in this arrangement, no.
Not in this,
Not in this arrangement, no.
so you're saying specifically in this way? When were they? Oh,
On an exterior door that opens directly to the outside. Not on a cross corridor door that gives you access to two separate and independent required exits.
just 1 second, I think that's it. Are you aware of the IEBC or IBC requiring a corridor between the two stairwells?
Say that again?
Are you aware of either the IEBC or the International Building Code having a requirement for a corridor between the two egress points?
What it more states is that you cannot access through a space to get to the second exit. So a way to do that is to provide a corridor. So you have clear, precise direction to an exit.
Right.
In this case, we don't have that.
You can't go through another person's space, right? And so, in your professional opinion, the issue is all about that the C space, people in the C area, in those rare times, would not have access to two spaces because this door might be locked and that door might be locked.
Counselor, look, the bottom line is the configuration does not meet code. It's black and white. It's not an interpretation. So we keep going round and round about this over and over again, and my story is not going to change. The bottom line is the code prohibits that arrangement with a locking door. Bottom line.
In your opinion, it's the same thing that Mr. Reithner made a mistake?
I would assume if that was the intent of his email, as some have read it, that potentially, yes. I'm not going to outright say he had all the information needed to make a determination to say he actually made a mistake.
Fair enough, you're not Mr. Reithner. Again, just one clarifying question, since we've referred to this gentleman all day long.
Sure.
What was his job title?
He was the building official.
So he was in his position, Mr. Reithner. Okay, I think I'm done.
Okay. Any redirect?
No redirect.
Okay. Any further witnesses?
No.
Okay. Thank you. This then would normally be the point where the attorneys could make closing arguments. I'm a little fried at this point, but I'm willing to wait and listen, or if you'd like to submit those in writing instead, I would be open to that, but I'll let you gentlemen quickly think through how you would like to make your final arguments on this.
I will take about 20 seconds.
Okay, Mr. Haney?
I'll try not to take much longer.
Okay, well.
Can't guarantee 20 seconds.
If that's the case, I don't recall who I had said would go first on final arguments, but I guess because it's ultimately his burden to convince me, maybe let him go last and have you go first, Mr. Haney. Does that seem fair?
That's fine. You've obviously heard all of the testimony and you understand the issue, so I'm not going to spend a lot of time walking through things. I will simply say that our point is that the code does not allow the door to be locked. The proposed or the solution that was apparently approved, if it was approved, and I'm not certain the documentation supports that, but if it was approved in 2013, the unlocked during normal business hours is not something that the code allows. The code is clear and the commentary is clear that that is allowed only in exterior doors, not in interior doors. This is therefore not in compliance with the code. The building official has the authority, both under the international existing building code, if he finds that it is less safe than it was previously, but also he has the authority, even without making that determination, to make code corrections to make sure that something is safe. And I went through that with Mr. Higgins. We'll provide you with that code section in full. But that code section says that you're to allow the existing building to stay as is, except in certain circumstances, and one of those is where the building official determines that a correction is needed for safety purposes. That's what's happened here. This is an unsafe situation for not tenant space, but the common space area C, and it doesn't meet the code, and therefore the building official has required the change. We'd ask you to sustain the decision of the building official.
Thank you, Mr. Haney. Final remarks.
Very quickly, permitted the same way 3 different times. There is no difference at all between tenant space A, tenant space B, and more importantly, the prior permitted tenant space B. And also, the idea that what exists now is less safe than what was permitted before is just honestly beyond our comprehension. The code clearly states that what was permitted before is allowed to continue because it isn't less safe. It's exactly the same. There are two egress points for each of the tenants, and for any invitee or occupant of that space while a tenant is there.
Great. Thank you, everybody. Like I said, we sort of briefly discussed the record's going to be left open just to the extent that we're going to have the city sort of say these are the provisions of the various versions of the code that we've been referencing. You're going to sign off and make sure that everyone agrees these are the provisions that were in place, and that's because these versions of the code, especially the older versions, are very, very difficult to find for free or anywhere online. So we'll make sure that happens. That said, I know time is of the essence, so I'm not going to leave the record open, like date-wise. I'm not going to give myself more time to write the decision. I will ultimately issue a decision in the next 10 working days, and just the sooner you get that document to me, the better for me, but I'll make sure that here, so with Memorial Day, it'll be 15 days, I guess. You'll have the decision 15 days or sooner on this particular appeal. So thank you all for being here. With that, we'll go ahead and call it today. Thanks. You guys can